The next matter to come before the court this morning is Hovnanian Oster Homes LLC versus City of Lorain Board of Zoning Appeals. The appellant has waived oral argument this morning. Counsel, you have 15 minutes with which to present oral argument. We have read the briefs and we are ready to see the order.
Thank you, Your Honor. And may it please the court, my name is Bruce Richter here on behalf of the appellee. And as the court has noted, the matter has been waived, so I appreciate the court's indulgence, and I'll try to be brief and hopefully open the floor to any questions that you may yet have subsequent to the matter, which has been pretty well briefed. I think there are three key elements. Judge Rothgary wrote a very detailed, I thought very well-reasoned decision, methodically going through the review process under 250604, as it is his province to do. And I think the key points here are, one, that the Board of Zoning Appeals did not apply the correct standard. There, as the evidence shows, there was real question as to whether or not the board even understood the variance review process, both under its code and certainly under Ohio law, which treats this as an area variance, and the standard is one of practical difficulty, not hardship, as Fire Chief Brown had pointed out pretty consistently. Under the code, under the building code, 1533-14, there really is a pretty detailed set of criteria for considering why there are riparian setbacks and then how to consider variances. As the applicant pointed out initially, and I think it's also worthwhile to note that this Board of Zoning Appeals in Lorain is comprised of the very same members on the Planning Commission. So the previous month, before the BZA heard the issue of the variances, there were two riparian setbacks. One is to allow us to put in a retention basin for stormwater management, and then the other is really just the grading of backyards. It's a 30-acre site. There is some floodplain area. As the applicant indicated up front to the Planning Commission, we're going to have to elevate some of these properties for the roadway, and the practical consideration is that we cannot make adjustments elsewhere on this site plan. We really have to deal with the rear yard area where we need to do the grading and install the retention basin. So functionally, the only reason for these variances is to effectuate what riparian setbacks are intended to do, stormwater management. And the two key issues there are, one, that you fight against erosive effects, and two, that you control water quality. You either improve it or certainly keep it as neutral. So the whole purpose of the request was to implement strategies that the riparian setbacks are intended to accomplish in the first place. We have a site that has some challenges, and accordingly, the overall design that was presented to the Planning Commission takes those into account. The Planning Commission approved the site plan, so the overall layout of the site plan is now approved by the city, subject to the concern that they all had as to the stormwater management issues. As was represented to the Planning Commission, experts were to be hired to undertake this hydrology study, which in fact happened. As Mr. Barsikowski said to the Planning Commission, look, it costs a lot of money, so if we understand that the site geometry is acceptable, subject to this issue, then we can proceed and we'll get the report. The Planning Commission said do that. The following month in February, come back, and we do have the report of these two experts. They lay out their methodology, and if you look at the rules of evidence under Title VII, they showed their data, they showed the process, and then they gave conclusions. And functionally, what was the substance of the report is, based on these criteria for undertaking the study, the site as proposed would not adversely impact adjacent properties, but in fact there could even be some improvement as to water quality and flood control. So the board was presented with this documentation. The applicant was able to explain further, and the applicant, Mr. Barsikowski, on behalf of Hovnanian Oster, he's a licensed engineer, so he's competent to testify about these kinds of site development issues. But unfortunately, in the record, what's also very evident is essentially the board members were just concerned. There's been a history of flooding upstream or in other areas. There were a number of residents who spoke out about those similar concerns. And at the end of the day, in matters of evidence, we can recognize supposition, speculation, concerns that people have that are very subjective, but evidence depends upon objective information. There's nothing to refute the objective information, that's evidence that's provided in the report, the presentation made by the applicant is the need for the variances. And the fact of the variances is that, one, they will be designed to provide water quality control and flood control criteria that the code anticipates. If you look at 1533-14B, the first thing that the code says, this is the city's code, you shall consider are there alternate ways to make adjustments, front yard setbacks or side yard setbacks. And the conclusion there was, well, no. This is part of the presentation made to the Planning Commission. So then you look at other factors where the board may consider other ways to obviate the problem. And if you go through that list, it's really a checklist. What the record demonstrates is, as presented to the Board of Zoning Appeals, this was, in fact, a project that's intended to meet the code goals and aspirations, but we need to work in this area. The yards are relatively small. There was one question about, well, maybe you could just do this without the variances. And the answer was, we would essentially have to elevate the entire site, or we'd have to build a wall around it. I mean, something that really was not at all practical whatsoever. I think the only concern that the board members had was they just had this abiding sense of, we have these variants, we have these riparian setback requirements. Even their engineer said that from what he could see, this would be make improvements, but he speculated that there might be some constriction of the stream. There is no evidence of that, as the Common Police Court noted, and on the contrary, Mr. Barsikowski had represented earlier, we're not going to constrict the stream. Everything that we intend to do from a grading standpoint will be in the detention functions. All of these are to provide stormwater management control.
When you say constrict the stream, you mean its normal flow or constrict the mechanism by which overflow is discharged safely?
Fair question. My understanding was, because it's kind of a wishbone arrangement where the site is bracketed by some stream areas, and there's going to be some grade elevation for the roadway, because this comes off of the Yeager Road, winds down through the site, and has to be elevated in an area to traverse the stream. Mr. Vandersomen thought that he just had some fear that somehow there would be future constriction of the existing stream because of this additional topsoil, or I think it was base soil.
So as part of the plan, there's no intent by the construction or the builder to do anything that would have a safety overflow should there be excessive water.
That, if I may, if I answer it this way, because I think that's
a layman's
correct.
question. I'm
Yeah,
not sure what I'm.
The stream itself is really not the problem. The stream will not be directly impacted. There's no diverting of the stream or
So the
modification of
stream
the stream.
is totally capable of handling all of that water.
Correct, because what we're doing upland of the stream on the site that's being developed, where we're changing the natural terrain, is we are adding these stormwater controls. So the whole purpose of grading and detention is to capture water that would be shed differently than heretofore. So in effect, we're saying we need these variances to do what you want us to do, but we have to work inside a certain setback area, the 75-foot setback area. We needed relief of about 25 feet to install the basin, and then in order for these properties to have some kind of a backyard, and mind you, having grass is not a preferred way to control things, but with the grading, with the overall detention, it will not overload or burden any further the stream. On the contrary, we believe that once the grading plan is finalized, and that is still subject to engineering review, we've got a preliminary site plan, but until we actually build and grade, inspectors come out, they make sure that we do what we say we're going to do. But the whole system is designed as an integral whole to control the problems that everyone was worried about. So in a way, it's somewhat ironic that the board just didn't even want to go through the analysis that its own code anticipates for making an intelligent and reasoned decision as to whether or not these are reasonable requests. So it was just an abject denial. The standard was wrong. I think the board lost its way. I think they just really didn't want to deal with it. And so what we have is a record that shows to the common pleas court, those officials charged with really administering their code failed pretty significantly in doing so. So the court went through the evaluation as it can under 250604, looked at the preponderance of the evidence and concluded one, does not support the denial. And really on the contrary, what the evidence does show, the preponderance of evidence on the whole record supports the request. And for that reason, we ask that this court affirm Judge Rothbeer's decision. And with that, if there are other questions, I'd be happy to answer.
Seeing none, thank you
All right, thank you.
for your presentation today. The court will take the matter under advisement, issue a written decision which will be mailed to all sites as well as posted on the Ohio Supreme Court website.
Thank you.